Good evening, everyone. Welcome to this online webinar on the dialectic governance and justice, conceptualizing and implementing the rule of law in Sudan, held by Fikra for Studies and Development and organized in collaboration with Democratic Media Center. Thank you for attending and thank you to our panelists for taking the time to join us today. I'm Hesham and I will be moderating this discussion on behalf of the DMC. Before we begin, I would like to introduce Dr. Amjad Farid Al-Tayyib, Executive Director of Fikra, for the opening remarks. Go ahead, Dr. Amjad.
Thank you, Sujud. Good day, everyone, and thank you for joining us in this important conversation. My name is Amjad Farid Al-Tayyib. I'm the Executive Director of Fikra for Studies and Development, which is an independent Sudanese non-partisan think tank committed to public policy research and advancement of political, legal, socio-economic understanding of the Sudanese dynamic. Our work spans a broad spectrum of inquiry about governance, economic reform, political implementation of legal theory, and social transformation, with a central emphasis on evidence-based approaches and grounded policy innovations. I would like to start my remarks by thanking our colleagues in the DMC for collaborating with Fikra SD in hosting and organizing this important seminar, and also to thank our distinguished guests, Dr. Khadeija and Ms. Jihan, for contributing to this discussion. Unfortunately, we had another distinguished guest, Dr. Ibtisam Sanhouri, who will not be able to join us in this discussion for some last-minute unforeseen circumstances. It's both an honor and an intellectual privilege to welcome you to today's webinar. It's a space that we hope will foster thoughtful dialogue and critical engagement and collective imagination about means of realistic yet just implementation of the rule of law in Sudan. This platform serves to share and discuss and even challenge the finding of our recent report titled with the same name, The Dialectic Relation Between Governance and Justice. And it's an attempt to find realistic means of realizing rule of law in Sudan. The report was co-authored by our fantastic and outstanding legal team composed of Rawan El-Sadiq, Wahaj, Kamal, and Mohamed, Hesham, young but yet brilliant legal researchers of Sudanese and of Sudanese origins. The report constitutes a critical intervention into Sudan legal landscape during and post the ongoing conflict, and it is specifically addressing foundational challenges to institutionalizing and realizing rule of law in both normative ideal and practical framework. The report is structured around three analytical pillars: a theoretical integration of the concept of rule of law in the Sudanese context, especially taking in account Sudan's unique legal and political heritage, and also retrospective assessment of the reforms that taken place in during the transitional period between 2019-2021, with focus on the institutional fragility and the trajectories of the reform. We are not taking the text to trial. We are trying to actually judge the practical implementation of these texts. And the third pillar is a forward-looking proposal on how international criminal law may inform and support a locally anchored rule of law agenda in the years ahead. There are issues like special tribunals, command responsibility, and the utilization of the international criminal law, and other issues that have been largely ignored in the Sudanese attempts to realize justice and accountability and even create a Sudanese model for transitional justice. This needs to stop, and we need to find practical ways and practical realistic means on serving both justice, good governance, maintaining stability, and realizing long-lasting peace. This work has done by this report have already begun to resonate beyond the academia and research work. Our researchers were recently invited to present these findings at the United Nations fact-finding mission on Sudan, where they contributed to a panel examining the judicial accountability and transitional justice. We received a lot of feedback, both affirming and generative, underscoring the importance of deepening the line of research and engagement and translating research and academia into actual policy implementation. In this spirit, we have convened today's session not to merely present these findings, but to listen, exchange, and to refine this collective thinking. We are looking for insightful interventions from our esteemed guests and speakers, and also from the broader platform through questions and answer discussions that would be at the end of the session. Ultimately, we thank you all, and we are looking for a more collective and engagement discussion about just, accountable, and democratic Sudan. Let's begin.
Thank you, Dr. Amjad. Before handing over the report authors to the report authors and researchers, I would like to run through some housekeeping rules. This webinar will be conducted in English. We will first hear from the report authors and researchers, who will briefly provide a summary, additional post-publication notes, and highlight key recommendations. Each author will have exactly 5 minutes. After that, we will hear from our 3 guest speakers. Now they are 2 guest speakers who will provide their reflections and feedback. Each speaker will have exactly 15 minutes. The floor will then be opened up for questions for around 30 minutes. We will end in the final 20 minutes with closing remarks. This event is currently being recorded and live streamed on YouTube, and it has been announced on Facebook and Twitter. In the event of any technical difficulties, please bear with us. If you have any questions, you may begin entering them into the chat function or save them until later. I will now hand it over to Wahaj.
Hello, everyone. I'm Wahaj Kamal. I'm legal researcher at Fikra for Studies and Development, and I will discussing the summary of the report. And now I will start. Thank you for joining us, and I want to share with you the presentation. And the report discussed how effective governance and meaningful justice are related challenges for Sudan in its recovery after conflict. It states that facing these challenges is crucial for the country's stability and rebuilding effort. The report highlights 2 different ways to think about the rule of law. One approach focusing on achieving fairness and equality, while the other emphasizes the importance of legal structures and process. However, the report cautions that relying only on legal structures without considering a real world outcomes can be superficial and harmful. It emphasizes that law is not just a neutral tool. It can be a meaningful of political powers and must consider legal ethics and power dynamics. The report confirms that the rule of law must be principled and politically aware. Additionally, the report looks at Sudan's recent history, particularly the transitional period after the 2018 and 2019 revolution. It reviews past reforms effort, nothing post success and failure. It discussed political division, ongoing conflict, corruption, and weak judicial system. A key focus of the report is the relationship between transitional justice and rule of law. It discusses how international criminal law can help hold accountability those responsible for crime committed during the conflict, forming an important part of rebuilding the legal system. The report argues for the applications of international criminal laws to support Sudanese legal development, underscoring the need to consider the various legal traditional present in Sudan, such as civil, Sharia, customary, and common law. The report affirmed the urgency of rebuilding the rule of law, especially when legal orders is threatened. The work is present not just for this work is present not just for academic purpose, but as a practical guides for informing justice and governance in Sudan. It's outline essential recommendation for enforcement the rule of law, promoting traditional transactional justice and reforming the criminal justice system. In the context of ongoing conflict and political challenges since April 2018, rebuilding the rule of law is critical. The report emphasized that sustainability legal framework should address both governance issues and past injustice while analysis processing legal matters in Sudan. It's draw on experience from high-level and purpose plan for legal restrictions and accountability. The chapters cover the development of the rule of law in Sudan, the reforms after the revolution, and the relevance of international criminal law for supporting justice in Sudan. Finally, the report concludes with policies recommendation for Sudanese leaders, civil society, and international organizations to help building a legal system that ensure both immediately peace and long-term justice. And now I will hand over the mic to my colleague, Rawan.
Thank you, Wahaj. Hi, everyone. And I'd like to just once again thank our guest speakers and our attendees for joining us today. My name is Rawan El-Sadiq, and I'm a senior researcher at Fikra. So regarding additional notes on our research, there are 2 points I'd like to touch on. The first is that due to time constraints, there were some research limitations. And so there are various channels worth exploring for producing more specific research. I'll just briefly give 2 examples. The first is that although we do analyze and critique the 2019 draft constitutional declaration and specific provisions, and we also recommend reformulating them to better their legal legibility for practitioners in particular, we would have liked to have actually taken that to task and to have conducted an in-depth exercise to produce alternative iterations. This would require a more extensive research project, but this could be done at Fikra alone, or, for example, in collaboration with Sudanese higher education institutes and the schools of law, or the MOJ itself, to involve legislators with previous experience. Additionally, something that we mention is legal training in our recommendations. And based off of some feedback that we received post-publication, we find that it would be useful to conduct a mapping of what exactly training on human rights and humanitarian law is available domestically to practitioners and lawyers, and to assess where there might be an oversaturation of courses and programs targeting specific crimes. So if we just briefly take the example of SGBV, sexual and gender-based violence, in the context of sexual assaults on females, although there is a documentation issue, there is a general understanding within the legal field and even beyond that these are important and they must be well documented. First of all, evidence must be robust. And there is ample opportunity for Sudanese lawyers to receive adequate training on that. There definitely also seems to be a willingness on the part of international counterparts and stakeholders to facilitate that. However, if we take an alternative lens, if we look at, for example, the targeted killings of males from certain ethnic groups, this also fits the SGBV label. However, it might not be at the forefront of discussions, especially, or it might also not be at the forefront of agendas for making sure that this is truly on the radar of practitioners. Outside of that, there's also the issue of enforced disappearances and arbitrary detention, rife. throughout the conflict, and this is a key issue that needs to be addressed. However, it might not always be on the agenda. There might not always be opportunities for international partners or regional partners, or even domestically, to focus on this type of crime as well, and to make sure that lawyers are well trained on this complex and kind of new and ever-changing legal concept. So this is something that we need to look into and to develop more timely recommendations for, to ensure that no legal concept relevant to the post-conflict period is neglected. The second point related to the context of our report that I'd like to make, and that I'd like to stress here once again, is that our report involves a reflexive exercise on the rule of law, quote unquote, field, and its proponents. It dissects its relationship with transitional justice, and it asks the critical question of whether transitional narratives could stifle or snuff out rule of law projects. Whatever the conclusion on our part as authors or report readers, it is crucial that the promotion of the rule of law in Sudan from here on out is a sustainable one, and that it forces us to acknowledge that independent and healthy domestic law promoting and supporting institutions should be the end goal in sight. A transitional justice project is ultimately one with a time limit, as witnessed in various international experiments, even in Sudan post 2005 or 2019, for example. It's imperative that what is developed and built outlasts the involvement of non-domestic stakeholders and remains a sustainable trajectory for the rule of law in Sudan. This was, for example, even expressed by victims of human rights abuses or crimes, expressed to foreign bodies and entities investigating this. Although they supported the robust enforcement of international law, and that may include cooperation with international bodies, they still wish to see a strengthening of the Sudanese judiciary, so that it may take over investigation and prosecution and adequately domesticate international law in its full capacity and application in Sudan. Lastly, this prospective rule of law in Sudan cannot succeed if its subjects are not actively engaged. Many of us Sudanese here and other stakeholders, we share a similar vision for what the rule of law in Sudan could look like, but perhaps we engage with this from sometimes a strictly professional mind. This must be shared, this sentiment must be shared amongst broader society, must be propagated and supported, empowering victims of the armed conflict. And I just like to note as a side here that many of us Sudanese today could be considered victims in one sense or another. So I appreciate that context when I or my other Sudanese colleagues or attendees speak. It's important that these victims of the armed conflict are empowered, and this can be done through legal awareness campaigns, conducting outreach programs to educate on rights available and protection mechanisms, and to adapt public information platforms, which will encourage public engagement and support for putting an end to the impunity. This is a meta-narrative for our report, and it's what we are doing now today. Now that we've covered the areas for further work and broader context, I'd like to hand over to Mohamed, who will discuss our more specific technical recommendations related to the application of international criminal law.
Thank you, Rawan. Good evening, everyone. I would like to start by thanking our esteemed guest speakers for joining us tonight. Thank you to DMC for their support in hosting this webinar, and a special thanks to Dr. Amjad and Mrs. Marwa Ahmed for their work within Fikra for the logistical work behind the scenes. I'd like to start by introducing myself. My name is Mohamed Hesham, and I'm a legal researcher in Fikra for Studies in Development with background experience in international criminal law, transitional justice, and decolonial legal critique. Now, I'd like to share insights from our work on the intersection of international criminal law and the pursuit of justice in Sudan, particularly through the lens of individual criminal responsibility. Sudan's legal history is complex, blending civil, sharia, customary, and common law elements. But despite this richness, it has faced a chronic absence of genuine accountability, especially for grave crimes like war crimes, crimes against humanity, and genocide. This is where international criminal law, or ICL, becomes indispensable. ICL emerged primarily to ensure that when a state fails or unwilling to prosecute egregious crimes, there is a legal mechanism to step in. It does so mainly through defining individual criminal responsibility, the principle that individuals, not abstract states alone, bear legal accountability for atrocities. This idea disrupts the old notion for impunity for political and military leaders who hide behind state sovereignty. In Sudan's context, this principle is crucial. Decades of impunity have allowed powerful actors to commit a systematic abuse with little fear of repercussions. A good example would be the ICC's Darfur case. Although it's quite politically controversial, it was landmark efforts to apply this accountability. Yet, as we see today, those efforts remain too narrow in scope. The ICC jurisdiction has not extended beyond Darfur and very unlikely to be extended, leaving vast atrocities elsewhere, including the current violations by both SAF and RSF, unaddressed. This really points to a jurisdictional paralysis, a systemic blockage where political dynamics at the UN Security Council prevent wider ICC involvement. Our research argues that to break this deadlock, jurisdiction must be reframed as a strategic tool rather than a procedural obstacle. And this will be researched further by Fikra and by the legal team in Fikra. And if we can creatively expand or complement ICC jurisdiction, for instance, through hybrid courts, regional tribunals, or stronger domestic special chambers, then individual perpetrators can be pursued wherever they hide. But legal frameworks alone are not enough. They must be backed by local ownership and political will. Sudan's mixed legal tradition provides unique opportunities. Customary dispute resolutions, Islamic principles of justice, and common law procedural safeguards can all be adapted to strengthen domestic accountability. If designed properly, this can reduce dependence on purely international solutions, which have proven to be slow and selective. Additionally, addressing individual criminal responsibility isn't just about punishing the guilty. It sends a message that the command structure, whether in militias or the regular army, will be held accountable for systematic abuses, from targeted ethnic killings to sexual violence as a weapon of war. This deterrence effect is vital in conflict settings. Ultimately, our work aims to build a realistic roadmap for Sudan. First, by mapping out the barriers to applying ICL more broadly, may it be political, legal, or practical. Secondly, by analyzing lessons from other contexts. A couple of examples was the Special Court for Sierra Leone, which could be found in the research, and more importantly, the Gambia's hybrid court model to see what could be adapted for Sudan. And finally, by drafting policy recommendations to Sudanese civil society, the state of Sudan, and international partners on how to operate these ideas step by step. In conclusion, for Sudan to break the cycles of violence and impunity, we must make individual criminal responsibility not an exception, but a norm. This requires domestic and international courts to work hand in hand, innovative legal frameworks that reflect Sudan's plural legal landscape, and most importantly, a commitment that justice is not sacrificed for short-term political deals. And before I hand off, I would just like to point out a few recommendations that could be used as a guiding principle for the blueprint for transitional justice in Sudan. And it starts off with documentation of crimes. There has to be a building, as Rawan mentioned, empowerment of civil societies within Sudan. And this could be empowerment through reporting and monitoring, and the harmonization with other mechanisms such as the United Nations fact-finding mission. And this should help increase victim support to psychological, sexual, social, and legal expertise. This utilizes different kinds of investigative measures such as open source investigation and documentation, which has been widely spread throughout the war and before. Secondly, there should be a clear understanding of victim participation within the Sudanese context. As has been highlighted previously, victims are widely described in Sudan. So there has to be an understanding of who exactly is a victim, what qualifies as a victim. Is the direct harm or the indirect harm really what creates a victim? And there should be an allowance for victims to participate in a way of to recognize their suffering. And this modifies the charges through testimony, and it may even create a different avenue for the tribunal to look for. And this would allow for a better understanding of the case, paint a whole picture to understand the context of what is happening. This would express their independent voices. And then thirdly, the actual formation of the hybrid court could be in several different forms. May it be a international tribunal, a hybrid tribunal, or a completely domestic court. And this has to be through an understanding of past experiences, such as the two examples that I gave previously, and further the ICTY and ICTR, which are still functioning through the residual mechanisms 30 years plus after the conflicts. And there should be international and regional support. The AU suspension should be lifted immediately to allow for an interaction between the Sudanese state, or what is considered to be the current state, and to create a real transitional justice model through a criminal tribunal for accountability to be made. And I conclude by saying that individual criminal responsibility is a major importance to the Sudanese context, especially to focus on command responsibility through different regulations, such as the ICRC's international legal framework through Rule 53, that highlights that command responsibility is from the top down and not the other way around. Thank you very much. I'll stop here. I'll pass the mic back to Sujud, our host. Thank you very much.
Thank you. I would now like to introduce our next speaker, Dr. Khadeija Sheikh Mahgoub, who is a Sudanese assistant professor at the University of Khartoum's Faculty of Law, where she teaches, among other courses, international human rights and human rights in Islam in their diploma. She previously taught courses on the rule of law in a partnership program between the University of Dublin and Princess Noor University. She was the previous head of the research at the Saudi Human Rights Commission Al-Walid Philanthropy National Observatory for Women Creation, evaluating Saudi legislation in line with CEDAW and reviewed by UN Women. I will now hand it over to her. Dr. Khadeija, the floor is yours.
Assalamu alaikum and good evening, everyone. First, I would like to thank Fikra for Studies and Development for the kind invitation to participate in this valuable webinar. And before I start, may I just please share my screen with you all? Can everyone see my presentation? Is it seen by everyone? Could you please confirm to me? Okay, I can't hear, but I'm assuming it is. Okay. I would like to comment on the importance of such a study for several reasons, including, first, its comprehensive content, its timing amidst the developments that have occurred in our beloved homeland, which have manifested in the ongoing conflict in Sudan. Third, the organization that issued it, which is an active Sudanese organization primarily aimed at supporting democratic transformation in the country. Additionally, considering the youthful profile and the high research and knowledge expertise and scientific capability present among the young researchers of the study, this signifies the high human capabilities among Sudanese youth, who represent an important factor in supporting the concept of the rule of law in Sudan. Truly, all these four reasons serve as a positive indicator to highlight multiple aspects of the concept of the rule of law in Sudan, namely, the existence of an active local Sudanese national institutions. Two, the timely nature of the study, which reflects the interaction of citizenship concepts and responsiveness to the conditions of the country. Third, the comprehensiveness of the content that addresses several aspects of the concept of the rule of law in depth. Fourth, the esteemed national human resources of Sudan, represented by the three researchers as an important element in enabling and entrenching the concept of the rule of law in the country. Therefore, what I intend to convey today does not differ very much from the general perspective of the study that, and I quote, thorough consideration must be given to creating a uniquely Sudanese understanding of the rule of law that is sensitive to Sudanese politics and interpretations by local legal practitioners. End of quote. I am only attempting to fill in gaps here and there, or I'm trying to adjust the approach to achieve this matter also here and there. I begin by saying that the study has other positive aspects as well. And these aspects, when viewed through the lens of pure public international law, are also considered positive. Public international law, in one of its simplified definition, is a set of rules that seek to regulate interactions between international legal personalities, which are primarily and fundamentally states, and then international and regional organizations. In this way, it plays a complementary role with the domestic realm of each state through many principles, including the principle of state sovereignty. International law has evolved over the years, and its concepts have developed, such as the concepts of human rights and their international rules, as well as what is known as ICL, or International Criminal Law. These two aspects of international law have significantly evolved in their content and application mechanisms recently. One of the most notable features of this development is the special way in which they both interact regarding one of the main principles of international law, which is the principle of state sovereignty. From this perspective, the study we are addressing today has sought to clarify and discuss the applications of these two aspects of international law in the ongoing armed conflict in Sudan and its consequences. The study also discusses the requirements of international humanitarian law, IHL. As previously mentioned, the study is presented as a comprehensive Sudanese vision and links it to an important principle, concept, or legal situation to ensure the application of international human rights law, IHRL, as well as ICL, which is the guarantee of the prevalence of the rule of law. From the beginning, the report aims to cover past experiences. The report also speaks about providing ideas and backgrounds for conceptualizing the rule of law in a specifically Sudanese legal context, as well as exploring the relationship between the rule of law, transitional justice, and state building. To achieve this, the study, for example, delves into several conceptual definitions. One, the rule of law and its importance at the local international levels. Two, the political definition of the rule of law and its relationship with international institutions. Three, the concept of transitional justice and its historical development. Four, and many more concepts included in the study at their foundational level. It also provides a detailed and specific vision of the concepts of transitional justice and international criminal law. It offers a proposal to apply these concepts in the case of Sudan. It discusses Sudan's international commitments that assist and enable the adoption and application of the rule of law. It presents victim-centered concepts of justice and restorative justice. However, I have three general points that I would like to share today. First, the study has a strong focus on the lens and approach of international law in providing solutions. It also does not comprehensively cover the Sudanese reality and legal history. For example, on one hand, it talks about long-lasting impunity in Sudan. This leads me to discuss the methodology used in the study. While the methodology is in line with what is generally followed in legal research and the field of international law, I believe the study would greatly benefit from a re-examination of purely national legal and judicial experiences in Sudan to strengthen the concept of the rule of law both in the past and in our current time. The narrative of the study is based on generalization, particularly when discussing the root causes of the current issue concerning the rule of law and its development. It is notable that there are general statements about this subject within the study. In the aspect of long-lasting impunity, it is very important in this context and to build a correct and integrated Sudanese experience to recall previous local Sudanese experiences. This is essential for us to have a historical legal development that supports the process of definition, revision, and correction that the study intends to present. It is important to affirm that this matter began and existed many years ago in Sudan's legal history, including actions taken following Sudanese popular revolutions and significant uprisings that changed the course of the Sudanese legal and political reality. In this context, I recall, for example, the significant and detailed legal and judicial movement that occurred after April 1985 uprising, which sought legal rectifications of the damages following a long and extensive period of the rule of law and human rights, which lasted during what is known as the Mayo regime or May regime. In other words, the use of mechanisms of the concept of the rule of law. Legal and academic research sources revealed that this period carries within it a unique and authentic Sudanese experience. For many reasons, in terms of the large number of investigation committees, which reached nearly 50 committees. Of these, about 5 or 6 cases reached the courts. The various subject focus of the trials that took place, for example, in terms of holding some corrupt officials accountable, efforts to recover public funds, and the coup d'etat of May 1969 as a constitutional violation. The same period witnessed the famous Flasha trials and the trial of the murders of Imam al-Hadi, which discussed, for instances, issues currently well known in ICL, International Criminal Law, and mentioned in the study, namely, issues of relevant to command responsibility. The Sudanese courts delved into detailed discussion on the matter and rejected the arguments of the defense on following illegal orders. The court expressly discussed and referenced the Nuremberg trials and Tokyo trial, which reflects the ability of the local Sudanese courts in applying international law rules, and this supports the complementary role argument of the international law. The public trials were broadcasted openly to everyone. Despite some public discussions against this at the time, the idea of public broadcasting opened space for the Sudanese society to sit with itself, the Sudanese community or society. Similar approaches to the Sudanese experience have been witnessed later in other similar cases around the world. Also, the manifestations of reparation that took place, which did not have a punitive nature, for instance, are related to the massacre that occurred in the island of Aba, which ranked to the level of being classified as crimes against humanity. In such cases of reparation for the victim, for example, the transfer of remains of Imam al-Hadi, may mercy be upon him and his companions, to a non-graven omdurman comes to our minds. All of this confirms local capacity for accountability. Therefore, it is very important to continue exploring the mechanisms of these purely Sudanese accountability frameworks and to consider evaluating them and integrating any recent conceptual developments at the international law levels so that we address the issue of accountability during the current war or conflict and after. I believe that this also includes the trials that are currently underway to hold some officials accountable for crimes occurring during the ongoing conflict in Sudan. The study as a whole addresses aspects of international law and the role that international and regional law can play in supporting the transition to the rule of law in Sudan. However, it is important not to overlook the fundamental role of international law as it complements local law. Why is the above point important? It is important because a correct and accurate reading of matters leads to a precise diagnosis of the problem and thus to the provision of appropriate solutions. It is also very important to correct these concepts to integrate with the role of international law in Sudan, specifically regarding IHRL, ICL, or IHL. Gauging and amending are important because even at the time there was public talk about the role of the military in what is known as some of the political conditions that affect many countries in the third world, or even about the military and its intervention in politics. This is also mentioned in the study. This indicates that the military has not ceased its intervention in politics. And as everyone knows, this is not a unique Sudanese case. Correction is important so that we do not jump to conclusions and so that we can delve into the internal issues. To examine the obstacles to benefiting from the guarantees of the rule of law in Sudan, and to achieve what the study aims to present as solutions from within, and to achieve, what the study aims to present as solutions from within. My second major point is that there is a fundamental point which I would like to see being discussed in the report, which relates to the concept of the rule of the rule of law at the international level. Knowing that this topic is not new, for example, discussions on reforming international law institutions, including the UN. But what is new are the recent developments in regional and international events that make many people wonder where international law stands, or in other words, where is the international rule of law? Why is this question relevant to the study? The question is relevant because the study heavily relies on the role of international institutions in supporting the process of accountability and transitional justice in regional and international cooperation with Sudan, and calls for the creation of a hybrid court. I reiterate that I understand very well the pivotal development in the concept of ICL and IHRL, as well as IHL. However, it is very important to pay attention to the complementary role of public international law, which is a key feature of it. It is a fundamental and well-known role, mentioned, for example, by Lord Bingham in his book on the rule of law. In this context, it is correct to start from the Sudanese interior, its components, efforts, and reality by modifying the methodology in study and research. Also, a final question is related to the proper analysis of the events occurring in Sudan recently, or even in the past. And this is my third point, as the study talked about holding accountable those responsible for the ongoing armed conflict in Sudan. However, I hope that the study will be completed and will cover all those responsible for the war in Sudan, specifically regarding the external factors in the matter, accountability mechanisms, and their relation to international rule of law. Finally, I would like to second the importance of documentation mentioned in the study, as a lack of documentation has contributed to the issues I have previously outlined. While I understand the important role of the fact-finding mission, FFM, and the study's support for their work, the FFM still needs to understand the unique history and background of Sudan when making drastic calls, for example, expanding the jurisdiction of the ICC to cover the entirety of Sudan. I will now quickly show you some images and ask you to reflect on how they relate to Sudanese versions of the rule of law, to a Sudanese version of the rule of law. And before I do that, I would like to thank you, and I look forward to a fruitful discussion. I'll just go on the images that I would like to show you. I can't see the screen. Can you please confirm to me that everyone can see this, please? If I can hear you saying that, that will be very helpful, please.
Yes, Dr. Khadeija, we can see the screen.
Okay. Thank you.
Thank you, Dr. Khadeija. Thank you, and I would like now to introduce our next speaker, Ustaza Jihan Hinari, who is a human rights lawyer, researcher, and international human rights defender. She was formerly a human rights officer with the United Nations Mission in Darfur and director in Africa Division of Human Rights Watch, responsible for work on South Sudan, Kenya, Uganda, Tanzania, Chad, and Mali. Now I will hand it over to her.
Hi, thank you very much for that, Sujud, and thank you so much for being invited to speak to you and with you, and also for having invested in this topic. I think it's so valuable for Fikra to have been doing that and to be drawing more and more attention to this issue, and to maybe Dr. Khadija's point as well, highlighting and showcasing the work of younger Sudanese lawyers is so important at this moment. So with those words, I will make a few comments, I think recapping some of the points made in the report, but also maybe making a few points of my own, and reflecting on the current situation. I think I would say in contrast to Dr. Khadija's focus, I guess my focus would probably be reflecting a little bit more of what some of those international entities have been recommending, but also trying to put it in context. All right, so I'll start by, I think, making the observation that we have all seen the many legal and political obstacles to ending Sudan's culture of impunity over the last many decades. In my case, it was Darfur 20 years ago, and then now with the war. So, you know, the question becomes, when do we actually talk about justice if there is a war ongoing? And there is a debate around whether justice and accountability needs to wait for the end of the war and comes only when peace arrives, or if justice is something that can be done during the violence as a deterrent to raise the cost of abuse. So that is sort of one point, or question, I should say, that I think is a debate in the literature and a debate by people involved. But I want to first step back for a second and go back to 2019, because 2019 was the moment when everybody was quite hopeful that the transitional government could advance the justice sector reforms and accountability efforts. And indeed, they did try. And those of you maybe listening or were in Khartoum at the time, of course, remember that. And there were some reform efforts, and this report does describe those. And there were some small steps taken, I think, in reforming the law. But there were so many things, so many more things that were not done for largely political reasons. And I think we have to all acknowledge that some of those political reasons came from the military side of the Sovereign Council at the time, blocking initiatives for some of the justice-related reforms that were envisioned in the Judicial Council and the Constitutional Court, and cooperation with the ICC, for example, despite public promises to do so. And also blockages to the work of the June 3rd investigation committee that was mandated to identify people responsible, the commanders responsible for the attack on the protesters and the killings. And there were also failures in the civilian sector. And I just want to flag that, because I think this topic of justice is also an opportunity to do a bit of a lessons learned to the extent that that's possible. The transitional period was so short, and we have to be sort of realistic in what we think could have happened in that time period. But we also have to remember all the reasons for the blockages and the frustrations. and what brought us into this descent into war, which is our current reality. As I mentioned at the outset, one of the questions becomes, how do you talk about justice in the midst of a horrific war where atrocities are being committed at unprecedented scale? It feels much more important to say, how do you protect people from being killed and raped? And indeed, one of the theories in the human rights community to press for accountability during the wars, to raise the cost of these atrocities and make commanders to think twice. And for that reason, I think many of the recommendations tend to focus more on the international institutions like the ICC or like universal jurisdiction or the International Court of Justice, because those institutions nevertheless seem to exist on some other field. They exist out there doing work in the world, whereas within Sudan we see a complete crumbling of the justice system. So I think that explains why so much of our recommendation language is couched in the international institutions at this time. But in imagining the road ahead, and as the authors of this report have so clearly emphasized, has to do with longer term recommendations for Sudan. It has to do with legal education, with training lawyers, with reforming the Sudanese legal system itself, so as to have international criminal law elements, or just to be more effective in criminal justice, period. And these goals, which were all there during the transition, of course, are still very much a focus. And so when we imagine the road ahead in the world of transitional justice in this field, whether we want to use the word rule of law or transitional justice, I'm not sure that the nomenclature matters so much, but we are talking about accountability and justice, and we're doing it in the context of upholding the international standards. And so whether it's through international, regional, or domestic mechanisms, I think that this report really reflects an interest in upholding the international standards, if possible, which may take some long-term reform. So any sort of approach, I think others have said this for many years, and it came well in this report, is that it has to be a very comprehensive approach. One of the perennial issues that I noticed in Sudan during the transition that so many people also talked about was the overlapping efforts and lack of coordination, and how difficult it is to coordinate. Well, that's still very much the case when it comes to working on accountability today and on imagining a road ahead in transitional justice. So a comprehensive approach that takes into consideration all of these thorny issues. We have the issue of the temporal jurisdiction. Are we interested in, are Sudanese affected by this war interested in transitional justice broadly defined? And if so, back to which year? This debate has been a topic now for many years. And some people argue that transitional justice, if there is a project, a national project and a coordinated effort, that it should deal far beyond or back into the past. It should go back further than the onset of the war or the onset of the transitional period. So these are things that, of course, the lawyers interested in this topic have already been debating and discussing. Another thorny issue is the role of amnesties. Amnesties are not allowed under international law, under international standards, for the most serious atrocity crimes. However, there are many examples of countries that have, or projects that have adopted conditional amnesties for lesser crimes or in exchange for certain participation or reparation. So there are ways to maybe approach the question of amnesty in sort of also maybe taking inspiration from some of the examples like South Africa or Peru or others. And an approach to transitional justice also has to be very much victim-led, affected populations shaping it and leading it. And this is another big challenge that we saw during the transitional period in Sudan. In the context of COVID, especially difficult to organize the kinds of meetings and broad consultations that many people felt were essential for a transitional justice program to be developed. So we need to keep these principles in mind, and the victim-led aspects, and address these thorny issues like amnesties or immunities. Deal with this question of geographic and temporal jurisdiction, and many other questions that will arise. In addition to the international law that could be sort of the guiding principles, internationally accepted guiding principles, there's also the question of which mechanisms and which institutions would be part of a transitional justice project in Sudan. And in this regard, I would not necessarily say that that there is absolutely no one size fits all, and I think everybody would agree that the ICC is just a tiny piece of this puzzle. There are many organizations that are calling for an expansion of the ICC's jurisdiction beyond Darfur to cover the whole of Sudan. And if Sudan wanted to do this, it could authorize this, it could request this. And the expansion of the ICC's jurisdiction, of course, would mean that crimes committed during this war and over the whole territory would be investigatable and prosecutable potentially. The same discussion is happening with regard to the UN's panel of experts, which currently only looks at Darfur. So can these mechanisms be expanded? And indeed, there has been a lot of focus on other mechanisms, regional and national mechanisms. And as I mentioned at the outset, I think there's much less faith in national systems right now because of the war. And that is why there's been so much more emphasis on the regional and international ones. But I will pick on one recommendation that comes up over and over again that is quite interesting, which is this idea of a hybrid or internationalized court of some kind. We know that in the Juba peace agreement and in many of the Darfur peace agreements over the years, there have been many references to special courts. So far in practice, the special court for Darfur was not successful back in 2005. And probably a lot of good reason to be skeptical about a special court if it is established by the same authorities that are also implicated in the abuses. So going forward, what kinds of special courts or regional courts or hybrid or internationalized mechanisms are available? And I guess the answer is really anything goes at this point. I think there is a particular amount of interest in an internationalized court that would sit in Sudan, but have a mixture of international and Sudanese staff, and maybe a mixture of international and Sudanese law, or a Sudanese legal statute that incorporates more fully elements of international law to deal with the atrocity crimes. I've heard people discussing this for quite some time, and I think there's a lot of interest in it. I guess the one caveat now to note is that these take an awful lot of resources. And so it takes time and resources, and international actors would definitely need to be supporting such a mechanism, either from the region or elsewhere. And I would also want to point out the Truth Commission, which is another recommendation that I think makes sense, and I think it has gained more respect in the recent years there's been more interest in it, potentially paired with reparations. So truth commissions paired with reparations, like maybe Peru, Sri Lanka, South Africa, they have had varying degrees of success, but they have been, I think, more popular in recent years. No one size fits all, so there would have to be a good deal of coordination and participation by victims groups. And I wanted to add something on that, because one of the things that I noticed during the transition in Sudan that I thought was really remarkable and impressive was that there were, for example, the families of martyrs had started to coordinate very well together. And there were more efforts emerging, I think, that showed this level of coordination and interest in transitional justice, where you had martyrs or victims' family members who then became champions of accountability and justice efforts. So Sudan, I think there are many other groups that have formed, perhaps in Chad among refugee communities, perhaps in Uganda and elsewhere. They are starting to become more organized. And I think this is a really crucial element in any kind of transitional justice effort to create a more comprehensive approach and to have a more organized approach. For sure, having groups of people to be coming together and increasing their power as lobbyists and raising their voices. They will have more power if they can do that. So we've seen more examples of that in recent years, I would say, and even since 2013, actually, I remember. But I think this is an area of focus for many people now in this current context, and it's a really important element for any of these mechanisms that we've been discussing or that I've been kind of sketching out here, and for participation. And then I'll just end with a couple extra points on documentation. Again, sort of the problem of overlapping efforts or kind of maybe uncoordinated efforts is still an issue with regard to documentation. Now, the freezing of the funding from USAID had a huge impact undermining this, but an enormous amount is being done by volunteers and has nothing to do with organized funded efforts. And so it's I think important to find ways to get more coordination. Of course, one way of coordinating is by sharing as much as possible with the UN fact-finding mechanism, but again, that's the UN mechanism, and it's not the only way to do things. And I think there have to be multiple efforts within Sudanese civil society to have its own a way of archiving and categorizing and coming up with some of these guidelines that I think Mohamed was mentioning, if I'm not mistaken, about how do we even qualify ourselves as victims? I mean, there are groups of people who live in certain parts of the country who had a particular type of experience to do with looting or to do with many types of atrocity crimes have occurred in this war, but there are shades of differences depending on where you live and so forth. So this is something that Sudanese people who are going through this experience are best placed to do, obviously. And so I just want to emphasize that. I thought it was a very good point in the report. And then finally, when we talk about all the different mechanisms for justice, I think I had mentioned before the universal jurisdiction cases is another area where people have said, okay, look, because of the war in Sudan, national justice mechanisms are not functioning as well as needed for this, and so what else can we look at? And in addition to the ICC and the ICJ and the UN or the AU, there's also universal jurisdiction. Universal jurisdiction meaning the cases that are brought in national justice systems where the country has the laws on the books that allow for atrocity crimes to be prosecuted, regardless of where the victim comes from, and in some cases, regardless of where the perpetrator lives. So there are a number of countries in the world that have those statutes, and we've seen some examples already from past atrocity crimes in Sudan, South Sudan, and Darfur. And there is a great deal of interest in this for the current war as well. But I think, like all of this, these efforts are just getting underway. There is interest, and I think it's much to be seen, much to be done. But there are ways forward, and I think I've tried to point out a few of them. So the recommendations around expanding maybe the ICC or the UN or the UN panel of experts jurisdictions to geographical jurisdictions. Also the recommendation about an internationalized or hybrid mechanism of some kind that might sit in Sudan and have joint Sudanese and international staff, and more documentation, better coordination, and Sudanese-led, and formation of victims groups or strengthening of those groups as they are being formed. And then finally, I mentioned the universal jurisdiction cases, and to the extent possible to be looking at that, and the legal community can look at that. And I think with that, I think I've emphasized a few of the recommendations that I saw in the report that echoed well, because I've heard them coming up from many of the other circles. But I really want to express my appreciation for the perspectives that I've heard from Dr. Khadeija just before me, really interesting points, and from the researchers, Rawan and Mohamed. Really, Mabruk. It was really a very comprehensive effort in this report, with full of interesting points. So I'll end it there, and I look forward to any points of discussion. Thank you. Shukran.
Thank you, Ustaz Jihad. We are getting back to Dr. Khadeija for a minute before the question and answers. Go ahead, Dr. Khadeija.
Thank you, Sujud. Thank you, Sujud. It just came to my knowledge that my slides were not presented in full. So if I can I think it was only the first one that was showing. So I'll just do it quickly, if that's okay. But please confirm to me if when I start showing, if someone just to confirm to me, because when I move into another window, I won't be able to see what's happening in this one. So can you please confirm to me that you are able to see 1 and 2 slides? 1, 2?
2. Yes.
3? Okay. So this is 1.
The Fikra للدراسات العلمية.
This is 1. This is 2. I think. Okay. I don't know. No, right? Can you see them now?
No.
Just 1 second, please. I want to take long settings. Let me share my screen. I don't know how.
We can't see the screen, Dr.
You can see them.
No. Okay. We couldn't see.
Okay, I'm sorry about this. I don't know what's going on. You can see them now as well, right?
Not yet.
Okay. Sorry about this. Yeah, no problem. If I can just send them to DMC and maybe they can present them. Okay, I'm sorry about this. I don't know what's the problem. Maybe there is a technical issue. So I don't want it to take
Please send it to DMC.
much time.
Please send it to DMC.
Okay, I'll send them to, I'm not sure if I can send them to Miss Rawan, and you can please send it to
Yes,
DMC Rawan.
Thank you, Dr. Khadeija. We are gonna get back to you as soon as the photos appear to Rawan. We will now begin taking questions and opening the discussion for around 30 minutes. Questions can be written in the chat function,
Okay.
or you can put your hand icon and you can be given the microphone to speak. I will ask everyone to please keep the questions or comments respectful and under 1 minute. I will be interfering if the questions or comment gets too long. Please stay on topic regarding the reports and the speakers' reflections. Authors and speakers each have 3 minutes to give their responses. So we got like 3 or 4 questions. We'll start with them. Here we have Mohamed Shumina. He said, given Sudan's complex legal history, where law was often used as a tool of domination, how realistic is it to expect the rule of law used? I'm so sorry. Yeah. How realistic is it to expect the rule of law today to serve as a foundation of for justice and freedom? And does transitional justice in Sudan require not only institutional reform but also rethinking of what justice truly means? Who's gonna answer?
I took note of this question from the beginning when it was first asked. So if the other speakers or panelists don't mind, I'd love to just step in and then people can add from there on. So first of all, thank you for the question. With regards to this phrasing of the foundation for justice and freedom, if I understand it correctly, I feel that there's a bit of disillusionment in the question. Please correct me if I'm wrong. But I would like to stress here that the rule of law sits at the nexus of law and society. So it has a key role in state building and in the creation of a Sudanese state that's democratic and peaceful and that we all strive for here, I'm sure. So when we ask how, like, given the legal history, how realistic is it to expect the rule of law today to serve the foundation for justice and freedom? It has to. That's the simple answer. It has to be done. We need to be positive and in our outlook and creative in our solutions. That's the first thing I'd like to know. Strictly, secondly, this talk about not just institutional reform, but also rethinking what justice truly means. We get into that at the beginning of our report. It's a bit more philosophical, a bit more jurisprudential, but definitely there's just not an institutional outlook to it. Institutions are important, as our previous speakers have mentioned, but it's not just having a checklist of there needs to be this institution, for example, of human rights training, there needs to be an institution of a TRC or an internationalized court. They're not just checkboxes. Their mere presence is not enough. With that, there needs to be kind of a more, if we like, ideological or discursive push around that. So the rule of law, not just as strictly a legal perspective set of implementations, but also the rule of law as a general culture, first of all in our judiciary, then in our legislative, in our general nation state, and then even beyond that, as I mentioned, I think when I was speaking about the narratives, disseminating this idea that there will be a rule of law in Sudan, that that's the pathway. So it's tough, and that complex legal history, as mentioned in the question, we will identify it, we will just try to grapple with it. But I think, yeah, it's definitely not just, it's possible, it's not just institutional, and it's really something that we're going to have to live and breathe, as I hope we're doing in this session. So I'd love to hear what others think and how they'd like to contribute to this talking point.
Thank you, Rawan. Ustaz Jihan and Dr. Khadeija, would you like to respond to this?
Can you repeat the I'm not seeing the comment.
Okay, wait a minute.
Oh, wait, maybe I can now, actually.
Yeah, okay.
Oh, wait, it's further up. Sorry, can you just repeat the question? Oh, given Sudan's complex where law is often used as a tool of domination, definitely has. How realistic is expected rule of law and transitional justice require not only but also rethinking of what justice truly means? Yeah, I think so. I would completely agree with the assumptions in this question. Absolutely, law has definitely been used for political ends, and so have constitutions in Sudanese history. And so I think the idea of finding out what people think justice means through polling, and there's a lack of information about what people think, especially with this war. It's harder to do these focus group discussions and so on. So more of that around what people want, I think, is always going to be important. And the idea that the most affected people should be driving the thinking about what it means and what is transitional justice. As I mentioned before, I'm not sure that it matters whether we use the term rule of law or something else. I don't know, for the purposes of this discussion, I don't know that we should get too hung up in the terminologies. But that's my own view, and I don't want to speak for the authors. So I think I stop there.
I just want to jump in and just add on to what to what Ustaz Jihan and Rawan had mentioned, and just say that it's truly a function that is really pushed by the people, by the society. So the conceptualization of what justice is differs from one society to the other. And as Dr. Khadeija explained, there has been a multitude of experiences in the past, from independence to our day-to-day, that have shown that justice isn't really linear. That can't be one solution. So, for example, people in Darfur won't have the same concept of what justice is to what is happening currently in Khartoum. And similarly could be said about the different states in Sudan. So the conceptualization of what justice truly means has to depend on what the people would want. So the reparation or the retribution that they receive would be exactly how they envision it. And just to wrap it all up is just to say that this is led by the people for the people. And this just to take a page out of different reconstruction and rebuilding kind of methods. We should see, for example, Rwanda or Bosnia in the former Yugoslavia, how they really used those trials to rebuild and kind of conceptualize what their justice truly means. Thank you.
Dr. Khadeija, would you like to comment?
Yes, please.
Okay.
Well, I think my answer wouldn't be far away of what has already been said. I think the rule of law will always be needed, but the rule of law in itself is not only institutions, as probably everyone might argue for this. It is also a culture. It is a culture. It is in people's minds. It is not only at the level of institutions or the authority. It is also on the level of everyone in Sudan, in our private or our daily interactions. If we have it rooted in our minds and in our brains that we behave in a rule of law respecting way, for example, even for example, think about any institution like the university, for example, or schools. If we think about law as a method or as a way for solving our problems or solving our issues, and then we have a culture of a rule of law, in this way, I think rule of law will always be of relevance. Regarding justice, yes, but as Mohamed said, justice is not a straightforward meaning. Justice, again, what makes justice for someone, as Mohamed said, in Darfur, will not be the same for someone in Khartoum. It is a bit, if we can say, somehow subjective. There are subjective elements to this. So I still think rule of law is a valid way to measure things, but what type of rule of law are we speaking about? How are we conducting our lives with regard to our respect of the rule of law? It is not only authorities who take power into their hands. Sometimes in institutions, you find a boss who's taking powers into his or her own hands and not behaving in a way respecting the rule of law. So it is the culture of rule of law that matters to me. Thank you.
Thank you, Dr. Khadeija. I have another question for you from Mohamed Hesham. He said you spoke about past Sudanese experience. How would the most recent trials help for soldiers who committed crimes during 2018 and 2019 revolution be characterized to create a holistic criminal tribunal in Sudan? Secondly, nothing the roots and remains of the past regimes that you mentioned. How do you ensure, I'm so sorry, judicial and judiciary independence? I'm so sorry.
Okay. Thank you, Sujud. Okay, the question is from Mohamed Hesham. I'm still with my argument that if you want to have a rooted rule of law or rooted way of for having accountability, it has to come from within. I am an international lawyer, and it is my area of expertise. But I believe in the role of international law as a complementary method. International law by itself cannot do anything if it is not coming from Sudan and from within Sudan. As has been mentioned in the study, there are also other elements to this in terms of establishing or in starting having people who committed atrocities or crimes to be accountable. There are other issues, yes, definitely. But everything, even the other issues, say political or any other issues of relevance, they all have to come from within Sudan. So in order to convince a Sudanese community or a Sudanese state or a Sudanese official, you have to, for at least, even if not for anything, for practical reasons, you have to convince them that this is of relevance to Sudan. It is coming from our own culture and from our own experience. If we have this established and this thinking everyone agrees about, then we can apply it to every tribunal that took place in Sudan's legal history, whether recent or the remote ones. So, for example, the question about trials held for soldiers who committed crimes during the 2018-19 revolution, again, they have to go through the measure, them or others, as long as they were legal Sudanese genuine efforts to hold people accountable, they have to be taken into consideration, and things have to be built on this. Anything coming from outside, it is not the idea, even if it is not rejected in principle, it has to find a way to harmonize with what is happening in order to have efficiency, in order to make things efficient, in order to have healthy interaction with what is happening at the grounds in Sudan. Calling the Sudanese judicial system as being fully paralyzed is not the way out. It is actually working with what is happening on the ground that gets out will take us all to the way out. The second part of the question, noting the roots and remnants of the past regimes that you mentioned, how do you ensure judicial and judiciary independence? Again, I think this is a very, we cannot go about everything that has happened in Sudan that it has issued with the independence of the judiciary. What I was saying is that these things are documented, and their legal healthiness, if this is the right word to use, that they were not, for example, the examples that I gave were clear examples of good Sudanese practices. Now, the independence of the judiciary, there are other ways, and it's a big topic, and there are many things that goes into the independence of the judiciary. Appointment of judges, the interaction between the three powers, many things that goes into this. But definitely it is not something that should put us off from applying a Sudanese, from first of all recognizing and acknowledging our own Sudanese models and building on them, especially that they have proved. For example, the example that I gave, it proved that since the 80s, Sudanese courts were speaking about the command responsibility. They were speaking it and they were discussing it. It is very unfair to the Sudanese courts if we ignore all of this and we come and just start building as if we are building on a blank sheet. They have to come together. This has to come into consideration, and then adding whatever developments that have happened recently in the international level, the complementary feature of the international law.
Thank you, Dr. Jihan. Now we have Hesham. Want to ask a question?
No, I think you can go ahead. Go ahead. I don't have comments.
Hello, everyone. I have a comment. I agree with Dr. Khadeija. First, Wahaj Kamal. I want to thank Dr. Khadeija and Dr. Jihan for being a guest in our webinar. And regard to the question, the Sudanese legal reality, it's really complex, and we need more effort from the civil societies and the state to provide justice and to hold accountability and prevent them from escaping punishment. We need effort from state and civil society, and we need a real will from the state to hold justice and will for promoting justice and rule of law in Sudan. And it's a work for being collaboration with legal defenders and judicial in the state. Thank you.
Thank you. Thank you, Wahaj. Now we have Mohamed Hesham wants to ask a question.
Thank you. I'm just going to ask this question to both of the speakers. Remember the Rwandan Gacaca trials where nearly 2 million people were tried and 86% of them were found to be guilty and sentenced. And in the recommendations, also noting the recommendations of the report, we have spoken about the Sufi trials that could be implemented to ensure more regional kind of tribunals. But seeing how there's a destructuring and there's more severe crimes than what have these Sufi tribal leaders have dealt with previously, how could a Sudanese model similar to the Rwandan experience be implemented?
Hello, I can make a few comments if you like. I mean, I think one thing to remember is that the Rwandan model had benefits, but also a lot to criticize about it. With so huge numbers of people imprisoned for long periods without due process, and many sort of aspects of the Gacaca that were not necessarily very positive to be replicated. But I thought that discussion is really interesting, and how traditional Judea and other traditional justice systems within Sudan, according to the geography, how that could interact not only with the formalized systems in Sudan, but also with regional and international systems. So the idea is that there's a whole spectrum, and there's room for all of it, and a necessity for all of it. Remember, the ICC cases are against a tiny handful of people right now. And if there ever were to be a hybrid court or an internationalized court inside Sudan, it too would have a very limited capacity. It can't try everyone. So I guess my answer to you is, or my observation to you in response to that is that I wouldn't look at Gacaca as a model, because it has many problems and also features that are unique to what happened in Rwanda. But I do think there's large consensus that traditional justice in Sudan has to be part of a larger program, part of the efforts. So I don't know if there are others who have thought more deeply about how it would work. One of the problems that has been pointed out over the years to me when looking at the different systems is also, of course, they are not sensitive to gender-based violence. In Darfur all those years ago, when I was working on a lot of SGBV cases at that time, it was not appropriate for them to be going to some of the traditional leaders in their own view. So I think there are issues around gender and upholding international or human rights standards that need to be thought about as well and considered. But my discussions with people over the years in Sudan has always I've always heard people saying that they envision a role for the traditional systems, and it's more a question of how to activate that and organize it and empower them, and to make victims and people who would benefit from that type of justice to satisfy their needs. So yeah, interested in what others have to say about that, because it's a really fascinating part of this puzzle in Sudan.
Thank you. Dr. Khadeija, would you like to comment?
Okay, thank you. I think my comments again will be similar to what Ms. Jahan was saying. Personally, I'm not a big fan of the of the wording in itself by saying, how would another foreign model be of relevance to formulating a Sudanese model? Not of relevance to formulating a Sudanese model, but I mean would be a model in itself for the Sudanese model. That's why I speak always about methodology. I think we need to come up with a Sudanese model. How do we come up with the Sudanese model? By looking back into our own experience and our Sudanese landscape. For example, you spoke about, even the report did speak about Sudanese traditional measurements available for any form of accountability or transitional justice or mechanisms. We need to bring the Sudanese model. We need to bring on it. We need to work on it. What is the methodology for working on it? Is by exploring our own Sudanese model and knowing about it and knowing what, engaging it and see what went well and what went wrong. In this way, we can bring up our own Sudanese model. Now, does this Sudanese model match another model? That's something else. But from the beginning, we say, I know the report, for example, suggested the Sierra Leone model, but this is how I prefer to look into things. And this is what I see the word coming from within means. In principle, yes, there can be a need for any foreign or non-Sudanese mechanisms, purely Sudanese or local, but we have to come from bottom going up rather than coming from the international law and going into Sudan. This way we are not going to make it, and it's not going to be healthy. We have to come with our own, and then, so I hope I answered your question, Mohamed, but this is how I see things.
Thank you, Dr. Khadeija. Mustafa Adam has a question for Ustaz Jihan. Mustafa Adam has a question for Ustaz Jihan. Mustafa Adam. Okay, I'm gonna just read it. Okay. Hi, Jihan. Can you believe that ICC will achieve justice in Sudan? Ustaz Jihan, if you might answer this.
This is the $1 million question, my friend. We hope so. There's certainly some momentum because we have the one case that's going on. And during I remember in 2019 I was then with Human Rights Watch and going and visiting Al-Burhan. And he said that he was going to hand over those who are accused by the ICC. But it didn't happen. So look, the government of Sudan, the de facto government of Sudan right now says that it will cooperate with the ICC, but I don't see that happening yet. So it's all wrapped up in politics, and in terms of the ICC's own capacity, I'm not working with the ICC, but of course we all in the human rights community, we're all aware of the fact that that institution has a lot of problems with capacity and, a difficult birthing process. Well, now it's 20 years old, more than that. So, it's still a young institution, but I'm not going to defend it or beat up on it. Either way, it's there, and whatever it does on Sudan is going to be a small number of people. And this is really important. And the ongoing cases, the outstanding warrants, are all in relation to Darfur 20 years ago. There's nothing that the ICC, they're investigating what's happening now in Darfur, but they have not announced anything in this war yet. So we'll see. We'll see. I mean, for sure, they have asked to collaborate with civil society. They've asked for help, and they've been going to Eastern Chad. I know this, in order to investigate this current war. And of course, their jurisdiction being limited to Darfur means that they're just covering a certain feature, for certain aspect, certain chapter in time as well. So it's far from comprehensive, but I won't say that I have given up hope. I think that they may well come with something. And of course, there are the older cases. There's the Kushaib case ongoing, and then there are the older cases, which, you know, the warrants are out. And if authorities wish to cooperate with the ICC, we may see other trials from that era, from the older cases. So those are my 2 cents on the ICC, but it's hard for me to predict. Especially in these times, one thing that, it's a very difficult time globally now, as we all know. The ICC certainly is experiencing a lot of the same pressures and challenges as the other justice institutions in the world today. So, not a good time, but I haven't given up hope.
Thank you. Now we have Dr. Farid. He has a question also.
Comment. I think you brought, or Mustafa brought, a very important issue about the platform for justice, and for that there is an important thing that have been ignored largely by the international human rights defenders and others who are seeking justice in Sudan, which is the international jurisdiction in certain domestic platforms, especially using the command responsibility. Countries like Canada, legal frameworks like the one in Canada, the UK, and to some extent in certain legal frameworks of the US itself and other European countries. There is no yet political will from the International Human Rights Organization to actually seek accountability using these options, which will actually enforce the countries that has this platform to take more just and more principled political stance towards Sudan if there is an accountability options being pursued in its countries. So looking at your extensive experience, Jihan, and also Dr. Khadeija, from your knowledge about the international legal frameworks, what do you think about these options, and what are the practical obstacles, both political and realistic, in pursuing it? Thank you.
Sure, I can give my 2 cents if you like. So I think, I had mentioned earlier about universal jurisdiction being one of the areas that the international human rights and legal communities are pursuing at this moment. And that is more or less what you're describing, which is going to the national jurisdictions that have the laws on their books that would allow for prosecution of atrocity crimes, regardless of where the victims live or where the perpetrators live. This is universal jurisdiction. So there are efforts in this direction, and it has grown in popularity as an avenue for justice in the last, let's say, 20 years. And particularly in relation to Syria, there were some cases in Germany, and there are many other examples that we could look at. But for Sudan, I think it is of interest, and the legal community are trying, but it's not. There isn't a clear example in the courts as yet. That doesn't mean that there won't be. A huge obstacle here is getting the interest of the prosecutor in the jurisdiction that has those laws. So, for example, with regard to Syria, there are prosecutors in Germany and in other European countries that have given the green light and gone ahead with cases. Partially, that may be because of the large number of Syrian refugees who were in the country at that time. There may have been particularly good evidence. There may have been a perpetrator living there, easier to arrest, for example. So each case has its own set of facts and circumstances you can look at. But I would say in general, an obstacle with universal jurisdiction is getting the interest of the local authorities. They have to believe that this is going to work and that it's worth their time and effort. And if there aren't enough resources in the country or people from the affected country working on it in the country, then they may not think that it is worth it. So those are some considerations. Also, not every country that has universal jurisdiction has the same rules. Some of them really do require the presence of a perpetrator all the time or of victims all the time. So there are very few jurisdictions that will go ahead in the absence of either the victims or the perpetrators. So those are some really rough points. I'm not claiming to be an expert on these cases at all, but there are quite a few people who are interested in talking about them in relation to Sudan today, since the war. So that's what I have to say at this moment. And I think finding the right jurisdiction is the biggest, is going to be sort of their biggest challenge, and it involves so much coordination with the individuals, which perpetrators, where are they, and so on. So yeah, I'll stop there.
Thank you, Sadiq. We have a question for Dr. Khadeija. With the political complexities and emergency of large numbers of armies, how do we ensure that the commander is held accountable in the event of disorganization? Did you hear the question?
I'm sorry, I'm having some technical issues, but I think the question, is it with, yes, I think I found the question now. With the political complexities and the emergence of large numbers of armies, how do we ensure that the commander is held accountable in the event of disorganization? What a question. Well, I think, although I think the question touches on the complexities of things, definitely it is not only sometimes it is not only the law that is needed to solve the problem. There is also the need for other factors in the matter. If I understand it right, that if you are speaking about commanders and bodies in Sudan who are armed, if I'm getting your question right, I think one of the things that come into consideration here is international rule of law, which I've also spoke about in my comments, and it is a big thing, international rule of law, because armed commanders in Sudan, it is not an issue. It is definitely an issue that has the foreign factor of the Sudanese conflict, and how to bring them accountable is not. Yes, there are legal or local measurements to local regulations to have them accountable. But it is not only them. There are other factors that goes into this, which are the foreign factors. And I think here, the Sudanese regulations need to be revisited on how far they can go to reach even the foreign factors of the issue. That's one thing about it. But it is not a healthy landscape at all. The multiplicity in armed bodies within Sudan. How did they evolve? How did they get the chance to reach this level of being so armed? That's a big thing, and it is beyond. It is definitely about rule of law. It is definitely about rule of law within Sudan and rule of law at the international level, and many things that come into it at the international level. Not things are with straightforward international legal obligations, and other than that. I hope I answered the question, but I also have a comment about the international jurisdiction, if I may say, which Dr. Amjad was speaking about. It's about as you mentioned, Dr. Amjad. It is not. Here comes the role of non-state actors, and definitely it is an element that needs to be seriously considered. Ms. Jihan explained that the presence of the victims is not always required, but one question that comes into my mind and how to make it efficient, for example, many of the Sudanese officials who are being accused of committing atrocities or crimes are actually sanctioned, and some of them can they reach the countries where international jurisdiction could be mobilized? That's just a question to think about, something to consider, and that came into my mind. Thank you.
Thank you, Dr. Khadeija. We have a question here. Can we benefit from previous experiences and create a Sudanese model that is consistent with the complex Sudan reality? Dr. Khadeija and Ustaz Jihan, would anyone like to comment or answer?
I can start with this one, which I fully agree with. I'm just trying to find the question first. Is it in the comments or the private chat? Just trying to read it again, please. Sujud, is it in the comments or the private chat?
It's in the private chat.
Okay. Okay, I can't find it. But yes, there it is. Can we benefit from previous experiences and create a Sudanese model that is consistent with the complex Sudanese reality? Yes, I think we can. And I think we all need to have trust in the previous Sudanese experiences previous Sudanese legal experiences and other than the legal experiences. And when we trust them and when we explore them and when we study them, and then we bring the international models into them, together we can come up with the final Sudanese version or final Sudanese model. This is the practical way how to implement this on the actual reality is by doing this. We need to know them. We need to teach them. For example, the study spoke about the importance of education. We need to teach them to our practitioners. Sudan adopts Sudan accepts precedents, judicial precedents. So it should be taught in legal institutions, in universities. It should be training should include the Sudanese experiences. Wide wide knowledge should be spread about the Sudanese experiences, and with pride, by the way, because when we go back and find that from the 80s, we're speaking almost 40 years ago, Sudanese local courts did speak about the command responsibility. It is just how we are being fair to our own self by adopting our own Sudanese experiences and building on them according to international standards, which Sudan as a state, in many of them, is, for example, if we speak about human rights regulations, Sudan is a party to many mechanisms, and this is actually the obligation of the state to do this, but we have to build on it. Thank you.
Thank you, Dr. Khadeija. We have another question. It's also for you, Dr. Khadeija. How can legal practitioners keep public narratives around trials strictly legal and stop the encouragement of political narratives?
Again, this is an interesting question because I think it's also related to the rule of law. Professional practices are part of the rule of law. For a practitioner to practice in a professional way, this is part of the rule of law. And when you are during practicing your work, you have to be aware of any political elements of things, or public narratives, as the question says. So it is part of the rule of law in itself. When there are professional standards, by the way, for many of the bodies who are involved in the justice landscape or bodies of Sudan. So by implementing our own professional practices, we are away from public narratives and from personalization of matters. And I think, and this is again a good question, because this actually did interfere with the rule of law in Sudan, which the report did speak about to some extent. For example, we can ask the question the other way around. Why aren't our own past experiences that known to everyone? Why? To ourselves, to many of ourselves other than the outside? Well, I think because we are not sometimes implementing professional practices. But if we do that, then this wouldn't be the case. So, yeah, I think that's what I have to say. Thank you.
Thank you. Now we have Rawan El-Sadiq. She has a question. Go ahead, Rawan.
Hi, I'm being spoilt because I had the previous question that was asked was mine, and then I have another question for Ms. Jan. But I'm hoping everyone can get involved in the discussion. It's just that as an author, I'm really wanting to pick these two speakers' brain to get into what we can further write and research about. So my question now for Ms. Jihan is that you spoke about victim-led participation, right? And that's really important. We're constantly hearing about that. However, if we want to be more pragmatic and realistic, there is a real and true victim fatigue, right? In general, with any sort of process, not just legal, even humanitarian, but speaking about legal avenues, this victim fatigue is strong, and that can impact victim involvement and participation. You know, that's even been expressed, for example, I think you mentioned ICC reps have been to refugee camps in Chad and spoken with refugees, and I've heard ICC reps say that we were confronted by these refugees, basically saying we don't really have any faith in these judicial avenues, rule of law implementation. So my question is, how can we meaningfully address that victim fatigue? How can we address it in a non-patronizing way? How can we address it in a truly actualized way? So not just kind of platitudes about, oh yeah, we should include victims, but really creating the spaces for them to speak and to be involved. And I think you also mentioned a point about lobbying. and the involvement of civil society organizations. This is also interesting to me because at Fikra, we're a civil society org, right? So what's our role in that? How can we make sure that this victim participation is truly meaningful?
Yeah, I think these are great questions. I think, can you hear me? Yeah, okay. I think this is a really important thing about victim fatigue and the danger that sometimes presents itself when you have multiple investigators trying to interview the same people for the purposes of justice. And it's very difficult to avoid this because there shouldn't be a gatekeeper. For example, just because the one entity is trying to work with victims to collect testimony to use in a judicial process should not preclude that person, that victim, that person, witness, from speaking to others as well. So it's a difficult balance here. No one investigator really can be a gatekeeper and tell victims who to speak to or who not to speak to. This is a strange power dynamic that exists when you have international investigators working in a context like this. So there is that problem, and I've seen that problem especially in the past, and especially on the Chad border. I think one remedy for it is to always, if you are doing the research or the investigation, to always be utterly transparent about what you're doing, and also to ask people, you know, if you've already given testimony to entity X, you know, you don't have to do it again, or you can do it again, up to you, but just to be really good about transparency when you're communicating. But it is true that happens, and it's something to really try to mitigate and prevent, especially when you're asking people to recount crimes and horrific things that have happened to them. So there's a power dynamic that exists with regard to justice, international investigators, and so on. I think that having Sudanese refugees do investigations as well, be the ones leading them and participating in them, is another point. And some organizations do use that model, and that helps. But I think your point also raises another question about, you know, are victims tired of talking about justice? And I think that could be true according to some people, but it's not true according to many other people. So let them decide if they want to speak to somebody about their case, or if they want to pursue justice, or if they don't. I don't think that it serves anyone to assume that everyone is frustrated because one or two organizations may feel that and express that. It doesn't mean that numbers 3 and 4 do, etc. So we have to be careful in our assumptions as well. In other words, there are people that I have interacted with in Chad who have been in Chad for 20 years in refugee camps, and they still want to talk about justice for what happened to them 20 years ago. So let's not make assumptions, I think is my point here. Again, back to the thing about needing to have more public information and polling about people's perceptions and opinions. I think that's really missing from Sudan, not just from Darfur, but from all over the country. And with the suspension of different avenues of funding, it becomes more difficult because those types of projects do end up being a bit resource intensive. The second part of your question was about how to empower victims to do lobbying. And I think my point was really that efforts to help victims groups to form, I think moves them in the right direction, because there's more power in groupings. So having victims groups, which can then interact with these different mechanisms or with different investigators, different bodies, and they can also be powerful lobbyists if they are doing advocacy, maybe at the Geneva, for example, or New York. So the formation of these groups and supporting them to act in a collective in solidarity with each other, I think is always a good starting point. And if we are going to talk about a Sudanese model for transitional justice that needs to be led by Sudanese who've gone through these atrocities, then we need to help them to, or one would like to help them to have a voice, and forming a group it might be the best way to do that. So that was what I meant. I mean, your question about advocacy becomes more complicated because there's so many different types of advocacy, and that's maybe a kind of slightly separate question than supporting victims groups to form. Some interesting work has been done around formation of women's groups, and I think that specifically to talk about conflict-related sexual violence and reparations, that work to me seems very valuable, and I would encourage civil society to continue in that direction. In all of the other transitional justice examples that we like to invoke, we do see a quite powerful role for victims, and that is because of their sort of ability to convene, to reach consensus, to have a voice, and so on. So I think that work with victims and really understanding victimhood better, discussing more about the different categories or ways to define victimhood, I think is really worth undertaking at this moment. We're such early days in Sudan in terms of forging ahead with a Sudanese model, and we've all been talking about it for a long time. And on this webinar as well, what is a Sudanese model? And I really like the points that Dr. Khadeija is making about not picking from another model out there, but starting from inside Sudan with Sudanese first. You may see similarities with Gachacha or with Peru or with Morocco or something else in different parts of Sudan, but the starting point is really with these groups, and that's why helping these groups to be groups is really, and working with them to become more aware of what these mechanisms and opportunities are. I think this is a very important step. Yeah, so maybe I'll stop there.
Thank you, Ustaz Jihan. Now I'm going to give the opportunity to Mohamed Naji and, wait a minute. Mohamed Naji and Adil Khatir. They have comments, they have things to say. Please go ahead.
Hear me? Hello. Good evening, everyone. I would like to thank Fikra team for this effort, and a special thank for Rawan and Mohamed for opening this discussion during such a difficult time in Sudan. I also want to express my agreement with Dr. Khadeija on the importance of focusing on internal example of justice in Sudan in order to build an internal mechanism or a spiritual spirit of justice. Additionally, I want to thank Mr. Henry for her insightful point, and I believe she laid out a fundamental and practice step for re-engaging with the international organization, which is important to follow the international momentum. However, my point is that we need to put more effort into re-evaluating the value of Sudanese life internally and conceptually. We must also acknowledge that the challenge we face in Sudan is still governed by the same old regime mentality we protest against in 2019. And after that, we should know that we are not expecting a short-term change. So my question is, we should work more with the government that will be appointed in a few days or weeks to have internal small change in justice or documentation. Is my voice clear?
Can you please repeat the question, Naji?
My question is to Dr. Khadeija and Mr. Henry. Does we should work more with the new government that we will be appointed in order to have internal small change in justice and documentation as a pragmatic way or pragmatic step to do now?
Ustaz Adil, please talk after Mohamed Naji finishes.
Ma'am.
Thank you.
Shall I?
Okay, it seems like he finished. You have the opportunity, please, Ustaz Adil, talk.
Okay, Assalamu alaikum. First, let me appreciate and thanks very much Fikra and the team behind this report. I really highly appreciate it. And it's quite interesting to listen to this exchange of experience between the young generation and people with a huge experience like Dr. Khadeija and the other experience defender. So I have something like recommendations. It's not more than for the report. First of all, I do agree with Khadeija about when you are talking about transitional justice, we have to develop our own Sudanese modalities, which is quite, we have a good history and we have a good rich experience within this area. Keeping in mind our diversity in our culture, in our whatever, from south to the north to the from west to the east. Definitely here we can see a lot of diversities in how these communities, they are handling their disputes and their conflict internally within their context. So this can develop a good scenario for the future. The other things that's concerning the report regarding, I rather recommend the report to look into our national legislations, specifically about the Military Act, and also to look into the Criminal Act, where there is a very good positive development within these two acts. And these two acts will answer also the questions about the big number of militias which were developed within the recent ongoing conflict, which is create another problem of chain of command, command responsibilities, all these questions which is related to the conflict. And here you can look, when you look to our national legislations, Sudanese national legislations, you will find the room here to carry on the responsibility of the state. And here this state is another question about exactly whether they are willing, ready, willing to go for implementing the rules. And this is another questions. I don't want to go engage in this debate. But theoretically, there is a good model of two acts. I rather recommend the team to examine, especially Chapter 3 within the Military Act, and also to look into the criminal act within the procedure act specifically. And here, for first time, you will find that there is a room for transferring cases from military to the civil and from the civil to the military. This is happening for first time, but it's quite interesting to look into this point. Okay, another point for me, it's very important that we need also to qualify and to find the legal qualification of the situation, because it depends very much on what will be the future or how the engagement of whatever ICC or whoever. It's very important to have a legal qualification of the situation. Is it internal disturbance? Is it internal armed conflict? Is it multi between internal and external? How this can be qualified? This is, it's quite important to look into this subject matter, because it will have a lot of impacts on the future, how it will be handled, the whole case. Again, I do appreciate the effort exerted by those team, the member of the team, and appreciate it very much. And thank you very much, Fikra, for organizing this forum. Thank you.
Thank you so much, Shahad Al-Khatir. Now I'm gonna give the opportunity to Dr. Khadeija and Ustaz Jihan to reflect and answer the questions. I'm so sorry, in less than a minute, Dr. Khadeija and Ustaz Jihan, in less than a minute if you can. So sorry. Your mic is muted, Dr. Khadeija. Please unmute your mic first. We can't hear you. Yes.
Okay, sorry about this. I'm not sure if I got Naji's question right. If I have it right, do we need to cooperate with the new government that is going to be formed in the coming in the near future? If this is this your question, Naji? If this is so, in its effort in working towards accountability efforts or any justice effort, if this is the question, my answer would be definitely yes. And again, this is where we need to think about a government's work definitely involves politics. But for us lawyers and for us people who come from legal backgrounds, we need to look about any opportunity that will help establishing the rule of law or supporting the rule of law, let's say, that rather than establishing it from the beginning. So we have all heard, I think many of us have heard the speech by the newly appointed Prime Minister, and he did speak about his plans for justice, and I think it is giving. He called it the government of hope, and it is giving hope to many of us, and that's maybe something. That's my own personal opinion. I mean, every chance for establishing, for supporting the rule of law. Yes, everything has its positive aspects and negative aspects, but definitely wherever there is a positive aspect, people should not let it go. That's my own personal opinion, if I got your question right. Regarding Adil, I fully agree with him for his suggestions for the study, and he's actually going into the same line for the researchers in looking more into national Sudanese legislations and regulations, and trying to find what chances they can find there in order to come up with a Sudanese model of accountability. So definitely I do agree with him. Thank you.
Thank you so much, Dr. Khadeija. Ustaz Jihan, would you
No,
like
I have nothing to add. I think that was a perfect way to respond. I have nothing further. No further observations other than, you know, the politicization of justice is always something to watch out for, and so just be mindful that is, you know, that's always in the cards. So you know, I don't have anything more to add than what Doctora has just said. So I think I'll stop it there.
Thank you, Ustaz Jihan. We will now take remarks from our authors and guest speakers in the same order as before. I also encourage our guest speakers in particular to share their perspectives on each other's comment if they have any. Now I hand it over.
Hello again, everyone. I believe that the situation in Sudan requires intensive effort from the government and civil society and Sudanese lawyers to enforce the rule of law and promote the concept of justice and fairness and accountability in Sudan. And I would like to thank all the attendees and guests for the faithful discussion and rich participation. And I would also like to thank Fikra Center for Studies and Development and Democratic Media Center for their collaboration to organize this useful webinar. Thank you.
Just a few quick comments from me. A really insightful and rich discussion. Dr. Khadeija, she's given us a good deal of starting points for us as researchers to start conducting direct studies on previous Sudanese case law and legislation. Definitely something to expand upon if we're going to offer this unique Sudanese model for the rule of law and transitional justice. Well, we need to get stuck in Sudanese law as it is and see what we can take from the old and incorporate into the new. As for Ms. Jihan, I think her comments are really insightful, especially in terms of the question that I asked, and I was really interested in about victim-led participation and group formation and lobbying. That's something that I'm thinking about because I'm constantly wondering, okay, we're talking about Sudanese models, privileging the voices of Sudanese victims and non-Sudanese victims of this conflict. But how do we actualize that, and how can we make sure that it's not just something that's stuck in our reports that we just give nod to in our recommendations? So that's a lot to think about. I'd like to just kind of round off by thanking everyone at Fikra that made this webinar a possibility for us, especially Rawan, our program director, our program manager who did a lot of work behind the scenes to make this happen. I'd like to thank DMC for giving us this platform. I'd like to give a special thanks to my colleagues for doing this research with me and speaking here. Our guest speakers, their knowledge was just so useful, and I wish I could sit here longer with them to ask them more questions. And then finally, our attendees who brought up some wonderful comments and suggestions that I've duly noted and will be discussing with our team again. So that's all from me. Thank you.
So I'll be very brief and quick. Just to reiterate what my colleagues have said previously, I would like to thank everyone for the very fruitful discussion and for Fikra and DMC for hosting this forum for this, like I said, fruitful discussion. And to Dr. Khadeija and Mrs. Jihan, thank you very much for your contributions. You've given us a lot to think about and a lot to work on for the future. And hopefully, inshallah, that we provide research that'll be viable and resource very resourceful for the future of Sudan. And just to cap it off, thank you all very much for attending and for your participation in this forum. We hope to enrich this discussion further. Thank you very much.
For myself, again, just like everyone said it, I have to also say it, and I'm obliged to say that I'm really thankful to everyone involved in this discussion, fruitful discussion today. Once again, I thank Fikra for all the efforts being done in having this discussion today. DMC, the young authors of the report, Ms. Jahan, with whom I am very happy that I have been sharing this presentation today with, and I really I appreciate all the comments that she has mentioned. Many, even if there are certain things that we did not meet in, but there is a lot that we did meet with regarding the points that we did meet together regarding them. I very much like your idea about the victim, the victim-centered approach for bringing a Sudanese model. This is something really very much interesting to look at, and it goes with what you have been saying about. You did provide many practical and from the real world insights into things. So this is something that I really agree with you at, and I really finding very interesting. Thank you very much also to all the audience and all the questions asked. And yes, thank you.
Okay. Whoops. Thank you as well, everybody involved, for holding this session. Many more such conversations will be had, I hope, in an effort to support the development of a Sudanese model and to advance the goals of rule of law, transitional justice, which are interrelated, and above all, accountability and justice for the Sudanese people who have been suffering so much these last years. So I'm really appreciating the opportunity to engage with you and to have read your comprehensive report, and looking forward to any future discussion based on on any of that material. So please feel free, and also thank you to Fikra and to the audience for questions and thinking about this topic. Have a good rest of your evening.
Thank you, Ustaz Jihad. We have now come to the end of this webinar. Thank you so much to our guest speakers for their valuable insights, and thank you to our attendees for their involvement and interesting discussion. If you would like to follow up on future research from Fikra, you can visit their website or social media accounts. For direct inquiries, please email them. Thank you so much.